Meet Sylvia Ho, a lawyer who's got the legal info that business people need to know.
Hi, this is Sylvia Ho. I am going to do a short video on electronic signatures. I've been asked by a number of different clients over the last 6 months or so about electronic signatures, whether or not requiring a client or a customer to sign them is enforceable. And so this video is going to cover the law in Connecticut and in Massachusetts regarding electronic signatures. So just to set a context today, because we've gone through COVID, so many transactions are being conducted electronically. Very, very rarely do we print out a contract and have someone sign it. And so that trend is taking on for businesses. For instance, if you go to a facility and they ask you to sign a contract, it's quite possible for them to give you an iPad or some sort of electronic device for you to, use your finger and sign. That's been happening for a while, but now what we're seeing is email and text with contracts that require you to acknowledge by signing. And there you touch the area about the signature and you make an agreement. Now, I do that too. In my practice tries to keep up with the latest trends of business because I represent business owners. And so what I'm going to cover right now is whether or not you can use that electronic signature if you need to enforce it against the party who's violated some sort of part of the agreement. So what I'm going to show you is the law in Connecticut and Massachusetts. Both laws are created under a uniform act concerning electronic transactions. And they're very similar. You're going to see that here. So what I'm going to share with you right now first is the Connecticut law. And what I'm covering right now as I go up on this, the name of this law is the Connecticut Uniform Electronic Transactions Act. And down here, we talked about electronic transactions. When you send an email to someone, that's with an agreement, that's an electronic transaction. A transaction, it can be recognized even though it's digital. It's not typed out on Word and then printed out and signed. So here we have the provision calling for legal recognition of electronic records and electronic signatures and electronic contracts. Here in Connecticut, it can be enforced. It says a contract may not be denied legal effect or enforceability solely because an electronic record was used in the formation of a contract. So there you're safe. If a law requires a record to be in writing, an electronic record satisfies the law. There you're safe. If a law requires a signature, an electronic signature satisfies the law. There you get, you're safe. Now here we have in Massachusetts, I have some clients in Massachusetts and also clients from Connecticut doing business in Massachusetts. Again, this is a uniform law. So let's go back to this is section 7, which is down here of the Massachusetts general laws. Let me just see, oops, gotta go back, sections on electronic signatures. And here it says a record, again, the same wording, right? Cannot be denied legal effect or enforceability solely because it is in electronic form. A contract may not be denied legal effect or enforceability solely because an electronic record was used in its formation. If a law requires record in writing, an electronic record satisfies the law. If a law requires a signature, an electronic signature satisfies the law. So I hope that this was helpful for you and puts you at ease. There are some caveats to this law for the most part. If you're doing business as a business owner, a small business owner, you can feel confident that the law protects you.